17/5/2014, details whereof have been given in para 7. The second sale deed was for 39,60,000. That the plaintiff also returned on 1/7/2014 all 4 checks of amount of 39,60,000 on so and so, amounting to rupees 9,90,000 to each of the defendant, which the defendant had given to the plaintiff on the date of executing second sale deed number so and so dated 17/5/2014. The defendant has put his signature in token of proof of receipt of 4 number of check mentioned above, annexure so and so. That thereafter the plaintiff, after receipt of his check from the plaintiff, Your Lordship, in my photocopy it is not clear, and I may be telling yes. Not encashed by them, managed to obtain the original sale deeds number so and so.
From the office of registrar and
yes. So these 2 sale deeds, it mentioned that he obtained, was able to obtain it from the registrar's office.
Otherwise also he is entitled, because the registration slip must have been dated. Unless a person produces that registration slip,
yes,
the original will not be handed over.
Yes, but they produced and it was handed over. And this we have mentioned. That it is mentioned here that the possession of scheduled land, as mentioned in schedule 2 and 3, was not delivered to the defendant by the plaintiff, although he had handed over the registration slip to the defendant on the basis of earlier checks received by the plaintiff. That the plaintiff state here that the 2 registered sale deeds bearing number so and so dated 7/2/2014 and number so and so dated 17/5/2014 executed in favor of the defendant has no legal value in the eye of law, because sale consideration was not paid to the plaintiff and delivery of possession was also not given to the defendant even after registration and execution of the registered sale deed. That it is mentioned here that no sale consideration was paid by the defendant to the plaintiff against execution and registration of the 2 sale deeds by the plaintiff in favor of the defendant. As such, the 2 sale deeds have no value in the eye of law. Accordingly, both sale deeds are required to be declared as null and void. That the plaintiff thereafter issued a legal notice dated 23/8/2016, though through their advocate to the defendant, asking him to return both the original sale deed which he had obtained from the registration office, even after knowing that he had not paid any amount to the plaintiff towards sale consideration, and repudiated both agreements for sale. That the defendant replied the notice of the plaintiff through his advocate by reply dated so and so, whereunder he claimed himself to be owner of by virtue of 2 registered sale deeds and refused to return the 2 numbers of original sale deed, knowing fully well that scheduled lands are neither in his possession nor he has any right, title, interest whatsoever, on account of non-payment of sale consideration, and also due to repudiated of both the agreement of sale by the plaintiff through legal notice dated so and so. It is stated here that the defendant had intentionally and deliberately cheated the plaintiff by taking back all his checks, 8 numbers, after getting the sale deed registered in his favor. That the 2 sale deeds executed by the plaintiff in favor of the defendant did not convey any title to him, and it has been repudiated by plaintiff by sending a legal notice dated so and so, on account of which the defendant is not even entitled to claim any right, title, interest or possession on schedule 2 and 3. That the plaintiff is entitled to get his 2 original sale deeds, which was obtained by the defendant in clandestine manner, because the plaintiffs have acquired a right to receive the original sale deed from the defendant which he has obtained after getting registration slip from the plaintiff by practicing fraud. And then suit is valued and declaratory nature is only claimed, and the prayer is for the direction upon the defendant to return the original sale deed as they are, the documents are null and void. That is the ground. And other reliefs have been claimed. Now, Your Lordship, may kindly see the written statement. Very interesting written statement.
consideration amount? Did they say that consideration was paid?
They say, yes, they say,
you tell us, then
they say that they admit that these checks have not been encashed.
that's an admission.
Yes. But they say that instead the total to consideration amount total comes to rupees 1 crore 2 lakh approximately. And we have paid 1 crore 47 lakh to you, not directly, but on your assertion we have paid it to your relatives, to third parties, and all those accounts have been proved by the defendant.
When the consideration is mentioned in the agreement in the sale deed itself,
yes,
there cannot be no substituted money.
now what is there interesting, they say that on your assurance we have paid it to your security which you had security staff, to third parties, and also to we have incurred expenses in legal expenses when a third party had filed a criminal case. We had incurred certain amount legal expenses. That also is a part of the consideration. That is the defense. Now, Your Lordship may kindly see the written statement. I'll place
still
that.
the suit was dismissed.
Yes.
By on what ground?
On account that because there is a registered deed which itself mentions that the consideration amount has been paid, so nothing, no oral evidence, nothing else can be seen because it is a registered instrument. Therefore, that has value in the eyes of law, and then it is dismissed on that.
Issuance of check does not necessarily mean encashment. Suppose in a situation, checks are issued and document is registered and checks are bounced. There could be a situation. What is the remedy?
Remedy would be, Your Lordship, there is a controversy on this. There are two judgments of Honorable Court, but Your Lordship, there are two kinds of them. We have to see on what, if section 54 says, if it is paid or it is partly paid and partly promised, so then there is complete sale. So for complete sale, it has to be shown that the amount has either been paid in total. That means that because, Your Lordship, the basis of
the moment the check is issued, a right is accrued to the person to get it encashed. Because payment is, it is not a matter of deferred payment. It is not a case payment by security. Checks once issued, maybe that the money would come to the coffer later, but that is good payment.
that is good payment. I will not say that it is not good payment. But Your Lordship, it has to be seen that that is the basis of the entire transaction where money is being paid and title is being conveyed. So once the essential ingredient of passing of consideration amount itself does not take place, how can the title pass? Title would pass simultaneously.
This is very strange case.
हाँ,
I must say,
ये difficulty है, difficulty, it is there. I will not. But Your Lordship, can a person, when my title is undisputed, and only last one line sufficient I will be, because Your Lordship would be considering all these matters. Now, can a person, if I am the owner of the land undisputed, I execute a sale deed based on certain consideration amount, and that all those checks, admittedly they are not paid, then can I be said that the transaction is a valid transaction and now I'll have to file a suit for money suit to get my money? Now Your Lordship may kindly see their own written statement. Main paragraphs are from 10 onwards.
Yes.
Would I? पैरा ऊपर में फॉर्मल है इसी के लिए हम स्किप
No,
कर
no, 7.
अच्छा 7
It starts from 6.
ठीक है इन्हीं का ये सिखा that the suit is barred under the provisions of specific relief act, that the suit is grossly undervalued. Admittedly, the plaintiffs prayed in the suit for return of two sale deeds dated 7/2/2014 and 7/5/2014 respectively. The value of the sale deed dated 7/2/2014 is 62,70,000 and the total and the value of the sale deed dated 7/5/2014 is 39,60,000, total being 1,02,30,000, but the suit is valued at rupees 36 lakh only, which is without any basis. Moreover, the plaintiffs assume that those sale deeds are null and void. Cunningly, the plaintiffs have avoided the prayer of cancellation of sale deed. This is evidently for evading payment of full ad valorem court fee. Be it may mention that the same plaintiff filed title suit number 74 of 2015 against the same defendant in this court for cancellation of aforesaid sale deed. The said suit was valued at rupees 1,02,30,000 and the plaintiff paid ad valorem court fee of rupees 50,000. Later on, the plaintiff withdrew the said title suit number so and so unconditionally. This vital fact has been suppressed by the plaintiff very cunningly. Therefore, the plaintiffs are stopped from assuming and alleging that the two sale deeds in question are null and void and the same were not entered. So,
How do you respond to this?
yes.
This is the technical.
it was not unconditional. Absolute answer to that. These
How
order
is
sheet.
unconditional?
Order sheet is already there that the suit was filed but it was withdrawn with a permission and the court granted me permission to institute another suit and the second suit was filed.
That
So this was
exhibited?
not an unconditional.
That was exhibited?
Yes.
That was
By
exhibit
them
number?
itself. By them it has been accepted.
Exhibit number?
Exhibit D.
Let's figure it out right here. Is that correct? Like they, exhibit D shows that they were given some permission to file it. So this statement, in written statement is not correct.
I'll explain that. It is correct. It is correct in the sense having permission only saves them from being precluded to file a fresh suit. But the fresh suit is the fresh suit. The difference between the two suits is what is the subject matter of highlight in this matter. Earlier suit, the prayer was different. In this suit, the prayer is different. In this suit, in the garb of prayer which is made in the present suit, they are trying to get the relief which was there in the previous suit, for which there are certain requirements to be fulfilled, which they have not fulfilled, which I am behind.
No,
So factually, I am admitting.
it is one thing to say, where once you say that the prayer is different, so you cannot plead res judicata. Once you say that the prayer is different,
No. In any case, if the permission
basically
has been
it
granted,
is for praying
if the
to
permission has
res
been
judicata
granted,
only.
then the CPC allows a fresh
No,
suit
the
to be filed.
permission has been granted,
Yes.
irrespective of permission. Once you say that the prayer is different, crafting a prayer is the work of the act. Right? They have got full right to craft prayer in different manners. One prayer may be leading to the same relief, but by itself does not say that it will be barred by this.
Not res judicata, about payment of court fees.
We'll come to that.
About
So far
valuation
as-
of suit.
So far as this particular fact is concerned, what is the finding of the trial court?
No, it did not go into that question.
Okay, it did not go. Okay, no problem. What about court fees? Court fees
Court fee is always a matter between the suitor and the court.
the court
And
can
the
always
respondent.
direct payment of
Absolutely,
the remaining
absolutely.
court fees. So we are
And
filing many judgments.
yes, and Your Lordship, now with regard to valuation, there are judgments. What is the effect of a valuation? Now, if the courts have held that if by valuing a particular suit, I undervalue it to bring it to the jurisdiction of another court, then I cannot be allowed to do it. But when
jurisdiction might not have changed.
there's no such
The
contention.
jurisdiction would not have changed.
No, it would not have changed. So how does it matter? The jurisdiction would have been with the subject. And this was not even their objection in their written statement, that by undervaluing we had changed the jurisdiction of the court. So it is not their objection.
So under such circumstances, if you are supposed to pay the ad valorem court fees,
Yes.
then you will be paying on the suit valuation, or you will be paying on the valuation as they are concerned.
Whatever may be the value, my prayer is only for a declaration.
That's right.
And that would be a fixed
Fixed
court
court
fee,
fees.
irrespective of crore or whatever amount I value.
This also has been dealt with by the learned panel.
This I'll have to, I'll verify and I'll say.
Issues, we can find it out from the issues itself.
I don't want to make a statement which.
We'll find it out from the issue itself.
Yes.
Because three technical issues are there. One is section 34, other is court fees, and third is this.
Your Lordship, the issues are there in page 5, internal page 5.
Yes.
Whether the suit is maintainable in its present form, whether the plaintiff has valid cause of action for the suit, whether the suit is barred by principle of waiver, estoppel and acquiescence, whether the suit is barred under the provisions of TP Act and Specific Relief Act, whether the suit is undervalued or properly valued. This is the exhibit issue number 5. Whether the present suit is barred in law owing to withdrawal of title suit allegedly filed earlier by the plaintiff, whether the plaintiffs were entitled to sell the property in question, whether the two sale deeds bearing so and so executed by plaintiff were in proper consideration payment resulting into transfer of valid title in favor of the defendant, whether the plaintiffs are entitled for a degree of declaration read without claiming possession or who is in actual possession, whether the
Let
plaintiff
us see the finding with respect to Roman 5 and 6.
Roman.
Roman 5 is at page number 29. Ad valorem court fee should have been paid. The court says that only 250 court fees has been paid and no evidence was brought. What does that mean?
Yes, fixed court fee.
Further, the defendant has not brought any evidence on record to show that the suit as valued was undervalued, but have submitted that since the plaintiff was executed for the same deed, ad valorem court fees should have been paid. Just tell me one thing. Is it necessary to value the suit to the same extent whatever has been mentioned in the as a consideration amount of the CG? Or the suit can be otherwise also valued? Suppose there is a suit for cancellation of sale deed of 1970, valued at 200 rupees or maybe 2000 rupees. and a person files a suit for cancellation in the year 2020, the valuation of the property will determine the valuation of the suit, or the present valuation will determine the valuation of the suit, or the valuation as per the deed would determine the valuation.
Your Lordship, this would be governed by Section 7 of the Code we have. And it says that as a plaintiff, I can value the suit. So it is not necessarily, as your Lordship pointed out. Now, this is a case where the recent transaction had taken place. Now, in a case where the transaction has already taken place 50 years back. So, with regard to that valuation, it has to be, the court has to take whatever value I am putting in my claim, unless the court finds, again what I had said earlier, that I had undervalued either to bring it to the jurisdiction of another court, or it was actually undervalued and I was required to pay a higher amount of court.
But the court is saying that for a declaration only to
Yes. So even if I would have valued 1 crore 2 lakh, then also I would have to pay 250 rupees, and even if I value anything. But yes, but one thing, that if my valuation affects the jurisdiction, then no such case is pleaded by either side, or neither there is any finding of the court with regard.
That's right. Okay, fine. This is one part. The second part is on the point of 5 and 6, no?
Five.
There were two issues which were very
Yes. Yes.
Was issue number 6.
Issue number 6 also. Six is at internal page 28.
20.
Whether the plaintiff suit is so and so. Hence, in the light of above, the suit was withdrawn with the liberty to file permission to file fresh suit. The filing of earlier suit and its subsequent withdrawal cannot be held to bar the present.
So this issue is actually decided in your favor.
Yes, but it
They are
says
not
that.
agreed by-
But it says that because my suit for other reason has been held to be not maintainable,
That's
therefore
right. That is
that
a
is
separate thing.
yes,
On merit, it has been held to be
Yes.
non-negotiable. And therefore, what about section 34 finding?
section.
And what is their objection actually with respect to section 34? You are referring to section 34 of Special Relief Act?
Yes, Your Lordship.
Right, yes. What is their objection exactly?
Yes, Your Lordship, it is there because everything, most of the things have been decided by the trial court while dealing issue number 1 itself. Is the suit maintainable in its present form? So while deciding, majority of portion has been discussed by the trial.
Including this section, this Special Relief Act. You claim that you were already in possession.
I say that I was in possession, and they say that they are in possession. You see.
But since you did not seek any relief of recovery of possession,
Yes, I
you
did not.
seek any relief of declaration of title. You just sought a relief that this agreement is null.
Null and void, and the prayer for direction upon them to return those to say. This was the only declaration. It has been discussed in issue number 3, 4 and 9. All 3 issues have been discussed together, and there section 34 is also there.
Page number 26.
In second portion, that means page 26.
Yes.
Your
In
Lordship,
the present suit.
after section 34 has been
Yes.
quoted, I
In the
will.
present suit.
In the present suit, the plaintiffs being executants of the sale deed have prayed that the same be returned since they are null and void. However, they have submitted that the possession of the land described in sale deed was with them and they had transferred the possession of those land for development in favor of one Arun Kumar Thakur from 12/8/2016. However, the present pleading is in contradiction to the two as is recited in sale deed marked as exhibit 1 and 1 by 1. Further, the defendant submitted that he was in possession of the land described in schedule of the sale deed. It was submitted that on behalf of the defendant that without seeking the relief of recovery of possession, relief for declaration would not be maintainable. In support of the aforesaid contention, the defendant has cited above case laws, namely so and so, all these case laws. And then next page. Above case law cited does not help the case of the defendant, since in the present case the plaintiff has not sought a declaration but has only sought a relief of return of the two sale deed. Further, the fact that any transfer of immovable property can only be made by way of registered deed as well as the fact that stipulation of a registered deed of sale being executed by plaintiff has been made in within 1 month from the execution of agreement of sale being 12/8/2016, and the fact of the plaintiff not bringing the same on record, that is registered sale deed in favor of Arun Kumar Thakur, shows that the agreement for sale has not been complied with by the plaintiffs themselves. Here I pause. There is some confusion with regard to this. Our contention was that we had handed over the property to a third party. This is what is being recorded. The plaintiffs claim that the possession is with Arun Kumar Thakur, who has been in possession of the scheduled land in pursuance of an agreement to sale dated 12/8/2016. However, the defendant has averred in his written statement that the possession of the land described in Schedule 2 and 3 are in possession of the defendant. Hence, both plaintiff and defendant, by way of oral evidence, have submitted that they are in possession of the land described in schedule of the claim. Hence, documentary evidence adduced on behalf of both sides have to be looked into, since it is settled proposition of law that documentary evidence excludes oral evidence. The two sale deeds marked as Exhibit 1 and 1 by 1, which are registered, show that the possession of Schedule 2 and 3 lands were with the defendant, whereas the agreement to sale marked as Exhibit 3, which has not been registered, shows delivery of property to Arun Kumar Thakur, who was not adduced as PW2 in pursuance of a general power of attorney dated 5/4/2017, marked as Exhibit 4. Further, Section 54 of Transfer of Property Act, which defines sale, provides that an immovable property of value of ₹100 and upwards can only be transferred by way of registered instrument of sale. Hence, only a registered instrument creates a right interest over an immovable property of value of ₹100 and more. The present suit has been valued at ₹36 crore. Here, tracking error. It is actually 36 lakh. It is 36 lakh. No. Therefore, unregistered sale agreement cannot be said to create a right in property, and nor can a general property be said to create a right in the property. An unregistered agreement to sale can only be given as an evidence to enforce specific performance of a contract, whereas a general power of attorney in favor of any person only creates a right of agency and does not create any title and interest over the immovable property. Further, the plaintiff have also not claimed any compensation with respect to the sale deed sought to be returned. It is a case of plaintiff that since the deeds were without consideration, the same ought to be returned to them, as it was submitted that the defendant were in wrongful possession of the sale deed. Hence, in absence of declaration to the effect that the same were invalid being brought, the prayer that they ought to be returned is not maintainable in the light of reasons as discussed under issue number 1 and these issues are also decided.
So the court said that unless we challenge the sale deed, it cannot be declared.
But I have made a prayer that please return as they are null and void. So I will be citing a judgment with regard to what would be the effect of whatever bad drafting we have done. What would be the effect that you will check.
What is the effect on a sale deed which is executed without consideration?
For all these, Your Lordship, it would be better that I place those judgments.
Yes, please.
That-
Those judgments are required.
Yes.
And read with the sections. Transfer property. So primarily it's a pure legal issue.
Yes, absolutely. Because
Although it's a personal.
it is not in dispute that the checks by which were mentioned in the sale deed, by that the concession. This is absolutely undisputed.
How many oral and documentary evidences?
First, Your Lordship,
On the point of possession, is there any other, only the oral evidences contradicting each other is there?
yes, but
Therefore, the
because
court went into the oral documentary evidence.
documentary,
You filed the agreement of sale,
yes,
unregistered.
unreasonable. So even if that agreement for sale is not there, then also what would be the effect? That has to be seen. Merely on the basis of an agreement for sale, I cannot say that possession is there.
You see, agreement of sale being unregistered, does it prevent specific performance?
No, it doesn't.
It just only prevents 53A.
Yes,
It
absolutely.
does not, because
Yes.
we are seeing so many agreements of sale post 2001 where agreement of sale is being taken care of, irrespective of it being registered. Even if the possession is there is a specific performance of contract and certainly be enforced irrespective of its registration.
Yes.
The only thing which is barred after 2001 is that you cannot have a relief under 53.
Yes, I cannot because
So
if-
therefore, the finding of the learned code that specific performance of contract could not have been executed and things like that because it is an unregistered document.
this was not correct. This could not have been. And but on my case, I could not have solely relied on the agreement for sale. That merely because I have entered into an agreement for sale with a third party, therefore I am in
So
possession.
the third party says that he entered into an agreement of sale and claims to be in possession.
Yes. So, Your Lordship, I had earlier in another case I had relied
Because in
on.
one case
My
I
apology.
have decided that merely because it is an unregistered agreement of sale, specific performance of contract is not part.
Not bad.
Because there was an argument advanced that this is unregistered and therefore they cannot be
No.
specific
Only as
performance
Your
of
Lordship
contract
pointed
post
out,
2001.
it is only with regard to when I seek a protection from the court,
That's it.
claiming my right under section 53A, then on the basis of an unregistered agreement, I cannot claim defense, take that. That is the only bar, nothing more.
That's it. Anyways, the entire thing will, okay, let's see the judgment which you say.
First judgment, Your Lordship, because I have made a prayer, I must face that prayer, that I have prayed that the sale deeds may be returned to me, but in the body, and as they are null and void, and in the body I have made all the pleading that because no constitution amount had passed, and therefore those documents were null and void, and no title whatsoever had passed. So this was the essential plea.
Since your case was that no title had passed, so there was no requirement to get it transferred.
Yes, yes. Because it was a void document. Your Lordship, what would be the effect of a pleading? This, Your Lordship, is. How the pleading and relief has to be considered. Para 37 onwards, Your Lordship, this discussion is there. This was also a case where the relief was badly drafted. Citation is 1951 SCC page.
According to you, what should have been the appropriate relief as a draftsman of the suit?
Yes, that it may be declared as null and void directly. And then I should have said that after such declaration, the defendant.
That word null and void is very much there.
It is there, but it is upside down. That is, we should have, that was the basis. So once.
Return should have been the consequence.
Yes.
That should have been the consequential relief.
Exactly.
The main relief should have been the declaration. But you have said
Yes.
that return and then it's null and void.
As it is, assuming that it is a null and void. But Your Lordship, in my pleading, I have very specifically said all the things.
You are referring to para number?
Para 37 onwards.
37.
That leaves at large the nature of the relief to which the plaintiff is entitled. In view of, I take, there being no contract to the contrary, the plaintiff only remedy under section 92 of Transfer of Property Act read with so and so. The question is, has this hit the suit so framed? The plaintiff has claimed separate personal relief against the defendants, as there is no personal covenant as between so and so. Para 39. The plaintiff has also asked for a declaration of charge and a decree under section 34 CPC. The declaration of charge and so. Your Lordship may skip 2 lines. But reading of the 2 reliefs together, here Your Lordship may take. The reading of 2 reliefs together, I am of the opinion that though the claim is inartistically worded, the plaintiff has in substance asked for a mortgage decree up to a limit of rupees so and so with interest against each defendant. No other kind of decree could be given under section 34. Therefore, though he has not used the word subrogation, he has asked in substance for the relief to which a subrogate would be entitled to under Transfer of Property Act. I would be slow to throw out a claim on a mere technicality of pleading where the substance of a thing is there and no prejudice is caused to the other side, howsoever clumsily and inartistically the plaint may be worded. In any event, it is always open to the court to give a plaintiff such general or other relief as it deems just to the same extent as if it had been asked for, provided the occasion no prejudice to the other side beyond what has been compensated. So this is my contention, Your Lordship, that now once judging my plaint or draft which I have filed, I have very specifically said, taken all the grounds where I have said that why the document which were executed by me were null and void, and therefore I was seeking return of those documents.
Now you come to the core issue.
Yes. First, may I place the written statement or place the judgment?
You have placed the summary of it, but you place the written statement.
Yes. Then I will place the judgment that
Yes,
without
then
translation.
judgment would be required immediately thereafter.
Para 10 onwards, Your Lordship,
Yes.
that read para 7. para 10 order, that with regard to the statement made in para 8 to 13 of the claim, it is submitted that although it was agreed between the parties that the checks issued by the defendant and mentioned in the sale deed dated 7/2/2014 and 17/5/2014 will be encashed by the plaintiff only after mutation in respect of the land mentioned in the two sale deeds, and in the pursuance of the same, the plaintiff retained the two checks with them. Still, the defendant paid. Here, the main contention is there. Still, the defendant paid the entire concession money of rupees 1,02,30,000 to the plaintiff and or their relatives as per their requirement and direction, partly by cash and partly by bank transaction on receipt of the aforesaid checks mentioned in the two sale deeds. Therefore, none of the sale deeds is hollow, but the entire concession money for those two sale deeds was paid in total. That is why the plaintiff neither filed a money suit claiming the consideration money mentioned in the sale deed, nor proceeded with earlier title suit number so and so as mentioned above for cancellation of those deeds. That with regard to the statement made in para 14 to 17 of the plaint, it is submitted that the plaintiff voluntarily gave the registration receipts in respect of the two sale deeds and also delivered physical possession of the land mentioned in the schedule of those two sale deeds. So the defendant collected original sale deed from the registration office on completion of the registration of the same, and further defendant applied for mutation of the land demised by those two sale deeds. As mentioned above, having received the full concession money on those two sale deeds, the plaintiff are stopped from challenging the validity thereof. So the contrary statement made in para 14 to 17 of the plaint are devoid of any truth. That with regard to statement made in para 18 and 19 of the plaint, it is submitted that repudiation of any agreement of sale by the defendant is totally baseless. The plaintiffs have not disclosed the particulars of any agreement for sale. Having received the full consideration money according to their own requirement and direction, in lieu of the encashment of the checks mentioned in the sale deeds, the plaintiff are stopped from challenging the validity of those sale deeds, what to speak of return of the original two sale deeds to them. Accordingly, the notice of the plaintiff was replied properly by the defendant. The defendant, having paid full concession money as per direction of the plaintiff and also taken physical possession of the suit purchased land, there is no question of cheating the plaintiff in any way. As a matter of fact, after taking possession of the land purchased by him through two sale deeds, the defendant commenced construction of several residential premises thereon after levelling the same by expending huge amount of money. Out of greed to grab those premises and alternatively to extort money illegally, the present suit have been filed by the plaintiff at the instigation of some mischief mongers. That the statement made in para 20 and 21 of the plaint are false and baseless. The title to the land passes with the execution and registration of the sale deed. Thereafter, the transferor cannot retain any right over the land already transferred by registered sale deed. The sale of immovable property is complete even on promise to pay the price of the land. The defendant has already paid the full sale price of the land purchased by him. So the notice dated 23/8/2016 from and on behalf of the plaintiff is totally absurd and illegal. Plaintiff are not entitled to get the original sale deed. The same were no obtained by the defendant in clandestine manner. Plaintiff themselves handed over the registration receipt in respect of the sale deed in question and made necessary endorsement in the registration receipt on the basis of which defendant collected those original sale deed after completion of the registration thereof. Therefore, there is no question of any fraud in getting the registration slips and registered sale deed. Once having received this again statement, received the full consideration money as mentioned in the sale deed and having endorsed the registration receipt in favor of the defendant, the plaintiff vendors acquired no right to receive the original sale deed either from the defendant or registration office itself. Out of their own wish, the plaintiff did not produce the checks mentioned in the two sale deeds to the bank for realization of the payment, of the amount mentioned therein. Anyhow, as a good gesture and being a bona fide purchaser, the defendant paid the entire value of the land mentioned in the true sale deeds as per request and requirement of the plaintiff in cash and rank transaction as mentioned on receiving back the checks in question. Therefore, the statement made in para 20 and 21 of the plaintiff false and concocted. That the plaintiff in para 22 of the plaint is totally absurd also. Neither the name of another person concerned nor the date of alleged agreement is disclosed. From the careful perusal of exhibit from schedule 1 to 4 of the plaint, it shall be evident that the land mentioned in schedule 4 is or was never in possession of the plaintiff. The major part of schedule 4 is in possession of the defendant. Since the date of execution and registration of the two sale deeds in question, the defendant is raising
The
questions.
fact that the checks were returned is not in dispute.
Not in dispute. Not in dispute. Absolutely, and those exhibits are there undisputed. Where he asks, calls me to return those on the ground. Now here the plea is that I did not produce it on my own. But the letters show that he said that this is contradictory to his earlier statement, that where he says that those checks were to be produced only after mutation was done. And he issues a letter to me that because mutation is difficult, you return those checks.
And first when you return the checks.
Yes, those exhibits are there. So, therefore, my contention would be, now the basis of the entire transaction was a consideration that the purchaser would pay me consideration and I would pass, the title would pass.
The sale deed was not based on a deferred payment.
No.
It is not that you execute the sale deed and after 2 years I will pay you the consideration.
No. And
then under such circumstances, you might have a right to realize that consideration amount, that deferred payment, but that will not call for a cancellation of it.
no, if the sale deed, this would have an effect, therefore I am making.
Yes.
If the sale deed itself mentions that out of rupees 1 crore, rupees 10 lakh or whatever may be the amount, this has been paid, and the remaining amount of rupees 90 lakh would be paid by so and so. So this would fall under section 54, where partly paid and partly promised. So I
It is not
cannot.
a case of partly promise.
No,
It is a
here
case of full payment.
full payment.
It is another thing that when you realize it from the bank.
Yes.
It is not a case of deferred payment.
No, it is not. So, Your Lordship, that was the basis. Now, the case falls in the first part of section 54, where it says that how the
There are numerous judgments on this.
but two essential. One judgment said something else in some other context that is being misinterpreted by everyone who is taking shelter of it, non-payment or part payment. 54.
Yes.
Sale is a transfer of ownership in exchange for a price paid or promised or part paid and part promised. So here it was, our case falls in the first portion itself. The sale is a transfer in exchange for a price paid. So if the price itself is not paid, the entire transaction is vitiated, is rendered void. Because other two conditions are that or promised, no such promise were there, or part paid and part promised. So this is also not there. Before placing judgment, if you see, I'll show the exhibits, because those exhibits are important for
Is there
Are
anything,
exhibits?
is there anything important left in the written statement to be read? Yes. Respondent. Is there anything, any particular paragraph in the written statement which has been left to be read?
Paragraph 10 and 11 are important, Your Lordship.
Okay.
And
Main things have been read, right? So
I've read 10 onwards, I've read entire.
Yes.
Till 14 I've read. One by one I'll show the exhibits, relevant portion of the. My exhibits are
Exhibit.
subsequently. Exhibits, the first one was one after the other. I sent a legal notice.
You come to exhibit 1.
No, first one is it was marked as X for identification. It is a letter, legal notice issued by us. But I must say, if it is not marked as exhibit, then I cannot place that document. So, in reply to our legal notice, their reply was there, which was initially marked as exhibit X by 1 for identification, but subsequently it appears that it was marked as exhibit 2. If your Lordship would see their reply, it is dated 9/9/2016.
Exhibit 2.
2. It is by Advocate Sujit Kumar Mato, only 2-page document.
Exhibit 2 is exhibit 5.
No, your Lordship, it seems that has also been marked only as X by 1 for identification. I'll skip that, your Lordship.
Okay. You just,
I'll skip that.
yes, himself stated in the written statement that mutation was an issue.
Mutation was an issue. Yes,
He has
absolutely.
stated in his
Absolutely, absolutely. And but I wanted to show
that
the
the checks
salient.
had to be encashed
Yes,
after mutation.
yes. And but I want to show the salient. That is
Salient
the
is exhibited.
yes, 1 and 1 by 1. This is the main document.
Yes. Yes, please. Please.
If your Lordship would see exhibit 1,
Yes, I'm
this is 7th day of February 2014. And it is between obviously plaintiff and the defendant. And the third page says, nature of the deed salient, consideration amount is 62,70,000.
That's right. It's no dispute on
Then. Internal page 9. Now this deed of sale witnesses. First paragraph. That in consideration of the said sum of rupees 62,70,000 only paid by the purchaser to the seller as mode of payment herein below, the receipt of which the sum the sellers hereby admitted and acknowledged as full and final and highest consideration of the schedule below land, the sellers by these presents do hereby absolutely sell, convey, transfer the all that land mentioned in schedule below in favor of the purchaser by the deed of sale. So, your Lordship may mark the first two lines. In consideration of the said sum of rupees 62 lakh, only paid by the purchaser. So, it is already been assumed that this amount has been paid. And then only, based on that, the receipt of which the sellers hereby admitted and acknowledged as for so and so, the sellers by these present do hereby absolutely sell, convey, transfer so and so. So payment of consideration
Is it
amount.
not something very, very peculiar that in spite of receiving the check, a person does not present it for encashment?
I'll come to that.
This conduct
Yes.
is
Yes. Both
very
entire.
fishy conduct.
I'll come to that.
This is not a normal conduct that a
But
person
I'll come to.
give the entire check back to the person.
I'll come to that. Your Lordship may see the then.
Schedule of payment is there.
Para 2, I'll only read relevant. That the sellers have delivered the possession of the suit below so and so to the purchaser will process so and so in all possible ways, and the purchaser shall be at liberty to get his name mutated in the office of the landlord of state of Jharkhand through CO and pay the rent on his own. And then the mode of payment is there in page 13. This is all the checks, same check, and the same is there in the second sale deed also. I am not required to repeat that. Then your Lordship may kindly turn to the exhibit 2.
Yes.
This is dated 22/2/2014.
Yes.
This is by Shivji Sharma, dependent, and it is addressed to the plaintiff. आपको यह सूचित करना है कि हम लोगों की बातचीत हुई, आपने अपना जमीन जो मौजा सो थाना सुंदरनगर की जमीन दलील के माध्यम से मुझे रजिस्ट्री की गई। हम लोगों को तय था कि म्यूटेशन होने के बाद ही तयशुदा रकम आपको देना है। इसका चेक भी दलील में अंकित कर दिया गया। जब हमने अंचल अधिकारी के पास म्यूटेशन हेतु दलील को पेश किया तो यह पता चला कि संबंधित थाना खाता प्लॉट नए सर्वे में सरकारी जमीन घोषित की गई है और म्यूटेशन नहीं हो सकती है। पूर्व में इसकी जानकारी के माध्यम से दी है। हमने अपने स्तर से काफी प्रयास कर लिया, अतः आपसे निवेदन है कि मेरे द्वारा दिए गए सारे चेक को हमें लौटाने की कृपा करें तथा नियम संगत दलील को रद्द करने की प्रक्रिया। Then 2/1 28/3/2014 मैंने सो एंड सो वो आपको पत्र के माध्यम से आपको सूचित किया था कि आपके द्वारा दिए गए दलील को आप रद्द करते हुए मेरे द्वारा दिए गए चेक को वापस कर दें, क्योंकि आपकी जमीन पर मेरा काम नहीं हो सकता है, क्योंकि लेकिन बाध्य होकर मुझे पुनः पत्र लिखना पड़ रहा है। आपसे तो फोन पर भी बात नहीं हो पाती है। कृपया यथाशीघ्र मेरे चेकों को लौटाने की कृपा की जाए, अन्यथा बाध्य होकर मुझे न्याय की शरण में जाना पड़ेगा। Then next page 8/4/2014. This is 2/2. सो एंड सो चेक वापस करने के संबंध में आपके द्वारा दिए गए सारे चेकों को वापस कर रहा हूँ, जिसका विवरण निम्न प्रकार है। And then it is signed by Satya Mohan Raju and left side signature of receiver that he received the entire check. Then this 1/6/2014 is related again, same document related to second sale deed, that please return my checks, and then same 2/3, 2/4 and 2/5 are related to the second sale.
Similar terms.
Similar.
You have this agreement also.
And then agreement for sale.
third party.
with her. Now, one thing I missed, Your Lordship, may kindly turn to the sale deed itself. Once again, only one line I've shown. Sale deed which has been marked as exhibit one by one.
One by one or one?
One and one by one.
I'll just
Both
refer to one only, because I'm marked here. It has the same terms, huh?
same. I placed that para 2 of that exhibit 1 where it said that he shall take possession and all those things were mentioned. There was no stipulation in the entire sale deed that mutation would be done only or encashment would be done only after the mutation is done.
It's not.
Now his own exhibits, only few exhibits are there. How he shows payment of consideration. Exhibit A, Your Lordship, may kindly see.
Exhibit A. Yes.
Although I have disputed this signature of mine, but this is a letter dated 16/2/2015. That is,
Because this, it has been marked with objection.
yes, marked with objection. A and B both. And the date of this letter may kindly be seen. The sale deeds were of the February 1998, 2014. And after approximately 1 year, this letter is being said to have been issued by me. And it says that as already discussed with you in connection with the payment of price of land sold to you, we have decided not to take the sale price of the land, said land by encashment of the checks issued by you and mentioned in those sale deeds, but in place of the same, we requested you to pay the same in different manner as per our instruction from time to time, and so that we may show payment to our other relatives, discharge our liabilities to our creditors, as well as payment of security services hired by us. We therefore request you to pay our following creditors up to a sum of rupees 19,25,000 by so and so. Exhibit A. Then Your Lordship may turn to next exhibit. This is dated 30/8/2018.
After 3 years.
Yes, and interestingly, after filing of the suit. Suit was filed in the year 2016. Suit was filed in the year 2016, and this is being said that this payment was made in terms of this letter, and I am writing it to the defendant on 30/8/2018 from so and so to so and so, same reference. Dear sir, as already discussed with you in connection with the payment of price of land sold to you, we have decided not to take the sale price of the said land by encashment of the checks issued by you in mentioned in those sale deed, but in place of the same, we requested you to pay the same by different manner as per our instruction from time to time, so that we may show payment to our relatives on so and so. We thank you for making payment of rupees 44 lakh to clear the dues of our creditors, which includes the payment directly made by you to our creditors as per our request and prior instruction. We further thank you for making payment of 74,80,000 to the security personnel deployed for the protection of ourselves and our family members as per our request and demand from time to time. So 74 lakh was paid to security personnel from time to time. We have also received rupees 5 lakh from you for the court expenses in connection with WPPIL with regard to our land in Moja so and so sold. So these are the consideration.
the checks were already returned, then we have decided not to.
Yes.
Why should
Yes.
it come in this
And
manner?
it was as if these checks were
Still
still
with us.
in existence.
Anyways, then
And then-
all these persons to whom this amount was paid, have they been examined?
No. Absolutely not. None of them. And they have not been examined. And interestingly, now plaintiff's defendant's own son comes and say that we had these amounts were the amount which we had taken from them. Some of those, not every. Some of the amounts were those amounts which we had taken from them
With their
for sale of
creditors.
the land to them, proposed sale of the land to them, and these amounts include the amount returned to them.
So he deposed on their behalf.
Yes, on their behalf,
In
his own son,
cross-examination he said, or
defendant's
in
own
he
son,
said?
own son.
In cross-examination.
Yes, in cross-examination. Yes. Your Lordship, relevant portion of the evidence of the defendant are placed because
You just see this exhibit A, right? Which has been marked with objection.
yes,
One of the person is Kalyani Day.
yes, and one is Rajendra Prasad also.
Radhin Prasad.
Yes,
The booking receipt has been exhibited, exhibit B, with respect to Kalyani Day. Flag booking receipt, exhibit B. Have a look at exhibit G.
Exhibit G, I'm
Yes,
looking.
Kalyani Day.
Kalyani. He is taking from
Shri Balaji Heritage.
this is the firm of the son of the defendant.
50,000.
50.
Okay.
Rest are your Lordship orders of ABA, and I'm not placing those exhibits. And bank statement is also there. My learned friend rightly pointed out.
There is a
Certainly,
transaction in connection with Kalyani Day because the letter is not reflecting what amount has been paid. But
No.
in bank statement, the amount of
it
Kalyani Day has been paid.
shows that if some amount has been, sum of rupees 80,000 has been paid to me.
Where is Kalyani Day's transaction? Oh, they say must have been returned by cash. We do not know whom did they return by cash, whom did they return by check. That is also not there.
Not clear. There,
Kalyani Day's transaction is not there in this.
her name has probably come in the evidence itself.
Her name has come in the letter. Exhibit A
Yes.
contains her name.
Yes. But her name has.
And this exhibit G reflects that she had some transaction in connection with sale and purchase of property.
Yes. And
Booking of a flat.
yes.
And whose Shri Balaji Heritage is?
It is the firm of the son of the defendant.
For where do I get this?
Yes. That from his own evidence.
What is the name of this person? Son?
Kartikeya. Is DW2. S. Kartikeya.
S. Kartikeya.
Yes, his evidence, these both Rajendra Prasad's name and this Kalyani day comes in paragraph in his cross examination. But I may be allowed to read the entire relevant, or I'll show
You
this.
just read the relevant here, whatever manner.
Yes. First, your Lordship may see the Shivji Sharma, who is the defendant. His relevant portions are these.
DW1?
He is DW1. Shivji Sharma.
Yes.
Para 4. Although your Lordship has taken note that the total consideration for both the sale deed came to rupees 1 crore 2 lakh. But what he says, that as per instruction from plaintiff, I and my sons have paid about 1 crore 47 lakh 62,700 on the following heads in lieu of checks mentioned in the two sale deed. Therefore, the plaintiff returned all those checks to me, as if after making all these payments, those checks were returned. Then it says, the headings are paid to plaintiffs and their family members plus TDS 3,20,000, creditors of the plaintiffs 44 lakh, security charges 74 lakh 80,000, plaintiff's court expenses in the case lodged by A.K. Thakur rupees 5 lakh, payment to A.K. Thakur as per order of Honorable High Court 20 lakh.
Who is this?
A.K. Thakur was the person to whom I had subsequently had given the property.
20 lakhs pursuant to the High Court's order.
Yes, it must have been a condition imposed in the bail order and therefore in ABA order. So that is a part of the concession amount which according to them. So the total amount is so and so. Then para 5. Details and documents with respect to these payments are in custody of my son S. Kartikeya, who is presently in Bangalore for his treatment. On recovery of illness, he will produce the document and he will depose in the suit. And then that the plaintiff have filed a suit to return so and so from me. Their allegation that the price of land was not paid by me and hence the sale deeds are null and void, and also that they are entitled to get back the original sale deed from me. Their case is totally false. In fact, no court declared the sale deed as void, and I have paid in excess of rupees 45,32,700 to the plaintiff. Both these sale deeds are legal, valid, and acted.
Any counterclaim filed? Any counterclaim?
No, it is not. Now, para 6 itself, second line, your Lordship may see. This is admission that the defendant knows what I am claiming. So this is in reference to my relief, which ultimately I have claimed. The allegation of the defendant that the price of land was not paid by me and hence the sale deeds are null and void, and also they are entitled to get back the sale deed, original sale deed from me. So the defendant knows that I am saying that the sale deed is, my prayer is that sale deed are null and void. He is well aware. So there would not be any issue that they were not aware. Then cross-examination, only relevant portions are taken. Para 9, next page. SMS राजू से चेक वापस लेने के बाद उन्होंने कब पैसा दिया उसका पूरा रिकॉर्ड मेरे लड़के के पास है। देन पैरा 11, पैसे देने के बारे में मेरे लड़के के पास बैंक स्टेटमेंट है और सभी कागजात हैं. देन नेक्स्ट पेज पैरा 18, सेल डीड के बाद एसएमएस राजू को मैंने चेक दिया था. पैरा 20,
के बाद
हाँ
तो वही लिखा हुआ है.
हाँ. Then I'll read 2-3 paragraph. सेल डीड के कितने दिन बाद जमा किया याद नहीं, मुझे याद नहीं कि मैंने सेल डीड के 4 दिन के बाद जमा किया, जिसकी सूचना मैंने प्लेंटिफ को नहीं दी. मुझे याद नहीं है कि मैंने नोटिस देके चेक वापस ली थी. मुझे याद नहीं है कि मैंने मुकदमा करने की धमकी दी थी. मैं मोहन राजू से घर का रिलेशन था, इसलिए मैं जो भी कहते थे मैं साइन कर देता था. इस मेरी जमानत में क्या क्या दलील वकील साहब किए मुझे जानकारी नहीं है. सेल डीड नंबर सो एंड सो डेटेड 2/7/2014 और सेल डीड डेटेड 17/5/2014 के आधार पर शेड्यूल प्रॉपर्टी पर अपना मालिकाना हक मानता हूँ और सबको बताता भी हूँ. मेरे नाम से म्यूटेशन नहीं हो पाया, मैंने इसके बाबत वादी से कोई चिट्ठी नहीं दी. Then para is not, let's say it was 29-30 stamped portion last paragraph. इसके सारे कागजी सबूत मेरे लड़के के पास है, अभी मेरे पास नहीं है. Everything what he answers is that his son was, and every document is with his son. Now therefore his son's evidence would be important, who has been examined.
ऐसी बात नहीं है कि क्या कोर्ट में 5 लाख रुपए के खर्च की बात पैराकोर्ट में हुई थी.
पैरा नंबर
वो खर्चा जो हुआ. Primarily he says that it was paid, but he does not have the evidence. If the evidence is produced by the
yes, and that too amount excess 1,47,62,700 was paid. Then because he for everything he says that my son has the account, so son's evidence would be important. S. Kartikeya is defendant number, witness number 2, and para 3-4 agree that my father tendered. I will read from para 2. That my father had purchased land measuring 3.38 acres in Mauja so and so from the plaintiff by 2 registered sale deed number in the year 2014 for a total price of 1,02,30,000. That my father tendered the sale price of the said land by checks mentioned in the sale deed, but the seller plaintiff preferred to receive the amount not by realization of the check through bank, but by direct cash payment to their creditors and security reasons, and by part payment to them, their relatives, etc. through checks and cash. That as again the total price of rupees 1,02,30,000 for 3.38 acres of land purchased by my father from the plaintiff, a total sum of rupees 1,47,62,700 has been paid to the plaintiff and or their nominated person from time to time as instructed and requested by the plaintiff. That by letter dated 16/2/2015, the plaintiff requested my father and me to pay up to rupees 19,25,000 only to their 11 creditors named in that letter. This computer printed letter 16/2/2015 has been brought by me, who by plaintiff, who after reading the content signed so and so. The letter should be marked as exhibit. I identify the signature of the plaintiff who signed the same. That by another letter,
marked exhibit, no?
It was marked as exhibit with objection, which is there in next page, where the court is now marking and noting my objection. It is just para 11
Correct.
to court. यह पत्र दिनांक 16/2/2015 को मुझे वादी ने दिया था, इस पर उनका हस्ताक्षर है जिसे मैं पहचानता हूँ, इसे प्रदर्श ए अंकित किया जाता है with objection that the signature is forged and not in not in not in
Not in original.
and then the second letter also, यह पत्र दिनांक 30/8/2018 को मुझे वादी ने दिया था, इस पर उनका हस्ताक्षर है जिसे मैं पहचानता हूँ, इसे प्रदर्श भी अंकित किया जाता है with objection that the signature is forged and not in. And then he refers to other payments. Then relevant portions, your lordship may come to para 11.12 of cross-examination by the court. Of examination by the court, I have already referred. Then
Balaji heritage का proprietorship form.
para 13 onwards are. यह बैंक स्टेटमेंट श्री बालाजी हेरिटेज जो मेरी प्रोप्राइटरशिप फर्म है उसकी है, यह बैंक स्टेटमेंट दिनांक 23/1/2014 से 23/1/2015 तक की कंप्यूटर जनरेटेड कॉपी है 2 पन्नों की, इसे प्रदर्श सी अंकित किया जाता है with objection that the money has been credited for different reasons. It is long cross-examination. I am only referring to relevant portions. Para then.
This particular statement is that this money might have been credited, but for different reasons.
Yes. And this was not even their case. Now the statement, your lordship may see the statement bank account. It is from 23/1/2014 to 23/1/2015. That means this, if it was prior to the payment which was already made to me, it must have been reflected in several correspondences or that I have already paid. Therefore, you please return me my check because you have been already paying. So all these, this is not even their case.
This objection is their objection.
That's right.
Just to
Their
clarify
objection.
this.
You see, what is happening? Father is entering into some kind of transaction in registration of his will. And this particular witness has its own proprietorship firm. He exhibits his bank account by saying that he has made certain payments. That is not your case in the written statement. You say that I have paid the amount in the written statement. It is not your case that your son has paid the amount through his firm. That is not your case in the written statement.
I was just pointing out, it's his turn to argue.
That's
I
right.
was just pointing out, I thought that
The
leadership is taking
objection
it
was
as
that
my
the
rendition.
payment is for different reasons.
I thought your leadership is taking it as our statement.
No, that it can't be your statement. It is their objection to the document.
That's really that.
Yes.
Now, till para 16, it is the court which is questioning and the answer is by the defendant. From 17 onward, the cross-examination by the plaintiff. मैं और मेरे पिताजी एक साथ रहते हैं. मैं और मेरे पिताजी सेल डीड के रजिस्ट्रेशन के समय मौजूद थे. सेल डीड के समय मेरे पिताजी SMS राजू वादी को 8 चेक दिया जिसका कुल रकम 1,30,00,000 रुपए था. तो सेल डीड
एक जगह कहीं बोले थे कि बाद में चेक दिया.
हाँ, ऊपर में लिखे, ऊपर में वही जो उनका क्रॉस एग्जामिनेशन में आया है, जो प्लेंटिफ का अपना यही डिफेंडेंट का अपना ही क्रॉस एग्जामिनेशन में है कि बाद में दिए. पैरा 18 सेल डीड के बाद SMS राजू को मैंने चेक दिया था. Para 18 of TW1
और TW1
TW
हाँ
yes
जिसको बोलते हैं सेल डीड के बाद
TW1 हाँ TW1 पैरा 80
यहाँ पे ये बोल रहे हैं कि at the time of
समय
सेल डीड आगे
सेल डीड के समय स्वयं मेरे पिताजी एसएमए वादी को आज चेक दिया था जो पूर्ण रकम इतना था। सेल डीड के मेरे पिताजी और वादी के बीच हुआ। मैंने डेवलपमेंट एग्रीमेंट आनंद होम मेकर्स के साथ बनाया था जिसमें अरुण कुमार ठाकुर और यूपी बनवा थे। दिस अरुण कुमार ठाकुर इज द सेम पर्सन टू whom we subsequently the डेवलपमेंट एग्रीमेंट कब बनी मुझे याद नहीं है। मुझे याद नहीं है कि यह डेवलपमेंट एग्रीमेंट पहले दोनों सेल डीड के पहले बनी थी या नहीं। बाद में 420 आईपीसी का मुकदमा अरुण कुमार ठाकुर ने वादियों के ऊपर किया और मेरे ऊपर और मेरे पिताजी के ऊपर किया था। मैंने सेल डीड के कंसिडरेशन अमाउंट में जो मैंने 20 लाख रुपए हाईकोर्ट के आदेश अनुसार अरुण कुमार ठाकुर को दिया उसको भी कंसिडरेशन अमाउंट का हिस्सा मानता हूं। मैंने कोई और डेवलपमेंट एग्रीमेंट नहीं किया है। मैंने सेल डीड में वर्णित जमीन का प्लॉट दूसरों को बेचने का एग्रीमेंट किया था एंड ऑल दीज ट्रांजैक्शंस आर रिलेटेड टू दैट अमाउंट। दूसरों को बेचने का एग्रीमेंट किया था। मैंने एग्रीमेंट करने पर पैसा लिया था और वादी को दे दिया था। मैंने उक्त सभी को पैसा लौटाया जिनका जमीन नहीं दे पाए। राजेंद्र प्रसाद को मैंने पैसा लौटाया जो कि जमीन खरीदने वालों में से एक ग्राहक थे। एंड दिस इज द राजेंद्र प्रसाद whose reference has come in the first letter. Exhibit A है this राजेंद्र प्रसाद। मैंने कल्याणी डेज से पैसा लिया था। गवाह को श्री बालाजी हेरिटेज का रसीद दिखाकर पूछा गया तो गवाह उसे अपने ऑफिस द्वारा निर्गत रसीद कहते हैं और पहचानते हैं। इसे ब्रदर्स जी अंकित किया जाता है। गवाह कहते हैं कि उन्होंने यह पैसे वापस कर दिए हैं। मैंने कृष्णा पांडे दुबे इंसान सो अजित कुमार से पैसे नहीं लिए। मैंने इनको पैसे दिए थे। इनको पैसे पत्र दिनांक 16/2/2015 जो ब्रदर्स ए में अंकित है उसी के आलोक में दिए गए। जिन लोगों को प्लॉट एग्रीमेंट द्वारा बेचने की बात की गई थी उनके कर्जदार थे। यह प्लॉट बेचने की एग्रीमेंट मेरे और लेने वालों के बीच थी। एसएमएस राजू के कहने पर ही एग्रीमेंट हुआ था। एसएमएस राजू लिखित परमिशन प्लॉट बेचने का दस्तावेज दाखिल नहीं किया है। ऐसी बात नहीं है कि मेरे एसएमएस राजू के बीच उपरोक्त समझौता जिसके अनुसार मैंने प्लॉट बेच रहा था कोई लिखित दस्तावेज नहीं है। 74,80,000 रुपया का सिक्योरिटी रखने के लिए एसएमएस राजू का मैंने पैसा दिया। सिक्योरिटी वालों को पेमेंट करने का रसीद है। यह रसीद जमा किए हैं या नहीं मालूम। जो केस अरुण कुमार ठाकुर ने किया उसका खर्च 5 लाख रुपए मैंने उठाया। उस खर्च के अमाउंट को भी सेल डीड कंसिडरेशन अमाउंट का हिस्सा मानता हूँ। ऐसी बात नहीं है कि मैंने सुंदरनगर थाना सो दिनांक 1/9/2014 को एक पत्र लिखा जिसमें मेरी रक्षा के लिए जसप्रीत रखा Then I'll skip all.
He is an employee of railways. The railway में superintendent.
ये शायद
Page number.
और शायद वो ही is
Page
probably
42.
Yes, yes.
हाँ
He is
he's
an
probably
railway employee.
हाँ पैरा 49 then last.
सर्विस के दौरान कोई भी व्यवसाय एम्प्लॉय नहीं कर सकता। ये तो खुद ही बोल रहा है मेरा प्रोप्राइटरशिप फॉर्म है।
व्यवसाय नहीं कर सकते लेकिन all these were
It seems that in the evidence they have tried to make out a case that pursuant to this agreement of sale, they entered into relationship with third parties, and then after it did not materialize, they returned the amount to them, And now they say that the entire consideration amount has been paid.
Yes, yes, yes. This is there. Para 49 also.
Just a moment. If they take the amount and they return, and this is being returned by DW2.
DW. What is separate one?
Certainly it has a separate form, but this is not a story made up in the written statement.
No. And one more thing, Yavaji. He is talking about a third agreement between him, Arun Kumar Thakur, and which reference is there, not this particular transaction, that on the basis of this, there was an agreement, my father took the property by way of sale it, and thereafter I entered into agreement with third parties. All these are not there. He's talking in reference to third case between him and those persons. And he is taking money from those purchasers and he is returning. So how that constitutes the consideration amount which he is returning to a third party. Then para 49 was referring to that we had taken this suggestion, we had put this suggestion that these exhibit A and B were forged and fabricated, and this was noted in our objection, which he denies, but we have taken specifically. Now this, even after this, this document was marked with objection that it was forged and fabricated, no evidence or expert was appointed at their instance to get it proved, even if it was could have been done, but this step also not taken. This sign also was never good. Even on
Which is the date of the first letter by which it is conveyed that it cannot be. This is 23. 23. On 22/2/2014, it was clear that the deal is to be cancelled.
yes.
And this exhibit G is money received on 16/4/2014, taking money from Kalyani Devi for booking of the flat. in spite of the fact that there was already clarity that the agreement is to be cancelled, they were still dealing with the property at best. And this is also not reflecting that it is in relation to the same property.
No, it is not clear. Therefore, I am looking for that particular place where it has mentioned that
No.
it is for this any
No.
area of this.
No, nothing is mentioned. Nothing is mentioned, and the development agreements or the agreement with third party have also not been brought on record,
No.
which would have reflected that it was dealing with which property.
Yes, it is not. Only these exhibits are there, which we have already placed.
Yes. What else do you want to say?
Yes, Your Lordship, two judgments are placed. That is. First one was Keval Krishan, Your Lordship, this. Para 18 onwards, Para 18 of Keval Krishan.
Yes.
Section 54 says so and so, so and so. Hence, a sale of an immovable property has to be for a price. The price may be payable in future. It may be partly paid and remaining part can be payable in future. The payment of price is an essential part of a sale covered by Section 54 of the TP Act. If a sale deed in respect of an immovable property is executed without payment of price and it does not provide for payment of a price at a future date, it is not a sale at all in the eye of law. It is of no legal effect. Therefore, such a sale will be void. It will not affect the transfer of the immovable property. So this is the ratio on which I am relying. And this, according to me, this would also cover cases where I have also executed the sale and price has not been paid to me. Then also it would have no legal effect and therefore it would be absolutely a void document. Now it says, now coming to back to the case in hand, both the sale deeds record that the concession has been paid. That is specific case of the respondent. It is specific case made out. Both the sale deeds record that the concession has been paid. That is the specific case of the respondent. It is the specific case made out in the plaint as originally filed that the sale deeds are void as the same are without concession. It is pleaded that the same are sham as the purchaser who were minor sons and wife of Sudarshan Kumar had no earning capacity. No evidence was reduced by Sudarshan Kumar about the payment of price mentioned in the sale deed as well as the earning capacity at the relevant time of his wife and minor son. And the sale deed will have to be held as void, being executed without consideration. And the sale deed did not affect in any manner 1/2 share of so and so, and it was held to be a void document. Thus, the sale deeds dated so and so will not confer any right, title, interest on Sudarshan Kumar wife, son, a sale deed will have to be ignored being void. It was not necessary for the applicant to specifically claim a declaration as regards the sale deed by way of amendment to the claim. The reason being that there were specific pleading in the plaint as originally filed that the sale deeds were void. A document which is void need not be challenged by claiming a declaration as they said we can be set up and proved even in this also.
Which is the other one?
Now, another judgment is, check 2025 SCC online, Supreme Court, 1961. 1961. Oh, acha. Page is 1961. Relevant starts from page para 29. Here, earlier case has been referred that Prem Singh versus Birbal discussed the position of law when Article 59 of Limitation Act so would apply. And referring to second proposition of section 20, para 29. Secondly, that when a document in question is void ab initio or void, a decree for setting aside the same would not be necessary since a transaction would be honest in the eye of law, owing to its being a nullity. And then next page, second paragraph, when a document is valid, no question arises of its cancellation. But when a document is void ab initio, a decree for setting aside the same would not be necessary as the same is honest in the eye of law, as it would be a nullity. Why I am placing? Because it was their objection that we had withdrawn, we had not prayed for a cancellation of that same. Then another relevant portion is para 34.
क्या paragraph passage को मिला नहीं
कौन
We
बोला?
are reading which paragraph? 39?
Oh, 29.
29.
हाँ, इंटर पेज टॉप में पेज जो होगा 13, पेज 13.
Para number.
Para number 29. Secondly, while referring portion of Prem Singh versus Birbal, secondly,
That's okay.
and then next page you will achieve at the very top, when a document is valid, no question arises of its cancellation. When a document is void ab initio, a decree for setting aside the same would not be necessary as the same is honest in the eye of law, as it would be a nullity. Then, other portions are there, but again, cable creation has been discussed in para 34. I am not referring to that. Para 34 onwards, no, 34 is the same cable creation. Para 35, after cable creation, para 35. As the facts of the present matter are concerned, the plaintiff specifically averred that she will never obtain any sale concession from the defendant. On this aspect, the plaint reads as follows: the plaintiff never got any sale concession of the alleged sale deed, and she came to know about this fraudulent transaction only when she came to the village to mourn the death of so and so, and heard that her land is going to be sold by the defendant without any right in it. Admittedly, the sale concession is rupees 15,000 as per the sale deed. The sale deed indicated that out of total sale concession, the plaintiff and other vendor, Ram Sharan, had already allegedly received rupees 9,000 from the defendant, and that remaining amount of rupees 6,000 would be received at the time of execution of the sale deed in front of the registrar. The relevant portion of the sale deed reads thus: now we therefore our sweet will have sold the above land measuring so and so with all rights of Srimati so and so. Possession has been delivered to the vendee. Out of the total sale consideration, we have already received rupees 9,000 from the vendee, and the remaining amount of rupees 6,000 will be received in front of the sub-registrar. Expenses of so and so to be so and so. The endorsement made by the sub-registrar at the time of execution is so and so, that the contents of the sale deed have been read over, and so on. The concurrent finding of both the first I'm reading para 38. Both the first appellate court and the High Court indicated that the husband of defendant Juan Bhagwat, who had allegedly given remaining sale consideration of rupees 6,000 during the execution of sale deed, had not stepped into the witness box. Furthermore, one of the attesting witnesses of the execution of the sale deed, Sarpanch, had also died before his deposition could be recorded. One Buddhu, who had second so and so, was the brother of the defendant, and both. All in all, there was no witness who could substantiate the case of the defendant that there was part payment of the sale consideration, that is rupees 6,000 during the time of execution of the sale deed. Furthermore, no evidence was adduced by the defendant to prove that even the initial amount of rupees 9,000, which was purportedly paid before the execution of the sale deed, was actually received by the plaintiff. Therefore, the averment of the plaintiff in claim that she had not received the sale concession had not otherwise proven as false. In such circumstances as well, in the absence of sale concession being tendered, the sale deed would be void and the plaintiff would not be required to seek its cancellation. Therefore, the Article 59 of limitation would not be said to be applicable in that circumstance. So this is my contention, Your Lordship.
Reply tomorrow. Reply tomorrow.
We started today.
Yes, yes.
You can continue.
Yes.
Or let me record his entire argument. I'll record your entire argument today.
Yes.
That would be better.
Yes.
जजमेंट लिखना शुरू करते हैं.
हाँ
एक ही बात है ना, पहले आपका सब कुछ
हाँ बहुत
plain
ज़्यादा
written statement कर लेते हैं.
हाँ एकदम
और जो evidences
ये हेल्प होता है but I have prepared the notes also.
So we take leave for 2 minutes. Yes.
लेकिन आज थोड़ा आधा घंटा में लिखा लेंगे, लेकिन आज आप शुरू कर देंगे.
जरूर करते हैं 2 मिनट.
ठीक है पुत्र. Thank you.
Summary he has prepared.
नहीं उससे नहीं चलेगा. First appeal में ऐसे नहीं चलेगा. Stakes are very high. This case is not going to be rest because.
अच्छा ठीक है. Then you are
कोई भी जीतेगा हारेगा जाएगा नहीं सुप्रीम कोर्ट.
अच्छा ठीक है.
इसीलिए things should be properly. हम just and.
अभी initially my submission may be taken.
हाँ अभी no I will take down the basic case of the plaintiff and the defendant. Then the list of the documents which have been executed, and then I will record your submissions and the citations I have.
So can I give this on Monday?
Not required. I will record it right.
Yes.
FA number 124 of 2023. This appeal is directed against the judgment dated 31/5/2023, passed by the civil judge in brackets division brackets 473 in original suit number 212 of 2016, whereby the suit has been dismissed. A petition, the ID number 1111 of 2025 has been filed seeking to adduce additional evidence before this court under section 107 in bracket 1 in bracket B read with order 41 rule 27 of CPC, annexing therewith photocopies of
We'll not press that.
okay. Has been filed, however, the learned counsel for the applicant on instructions does not want to press the integrity application. Accordingly, the integrity application seeking to adduce additional evidence is dismissed as one. The suit was filed for the following relief. the suit property, the properties mentioned in the schedule have been mentioned in 4 schedules. In 4 schedules, and the disputed property falls in schedule 2 and 3.
2 and 3.
And the disputed property falls in schedule 2 and 3,
which is a part of schedule 1.
which is a part of schedule 1. Schedule 4 किसके लिए है?
Schedule 4 वो हम बोले हैं कि वो हम अरुण कुमार ठाकुर को, that is not relevant.
The disputed property is relatable to schedule 2 and schedule 3, and both are admittedly part of schedule 1. Schedule 3 relates to sale deed number 705/508 dated 7/2014, and schedule 3 relates to sale deed number 2736/2125 dated 17/5/2014. Correct?
Yes.
It is not in dispute that the plaintiff was the owner of schedule 1 property, and it is also not in dispute that aforesaid sale deeds dated 7/2014 and 17/5/2014 was executed by the plaintiff in favor of the sole defendant.
Yes. There are 2 plaintiffs. Both of them have
By the
executed.
plaintiffs. Both sons of, by the plaintiffs. The suit was filed for the following relief and was valued at rupees 36 lakhs. 36 lakhs. 36 crores.
Yes.
Oh, you valued it at 36 crores, not at 36 lakhs. So undervaluation का तो कोई बात ही नहीं.
I stand corrected.
इसीलिए ना बिना प्लेन देखे कोई भी केस डिसाइड नहीं कर सकता.
Nay, then the trial court has rightly recorded that it was 36 crore. I thought that it was 36.
Anyways, we'll take care of it. Now since it has come to light, we'll take care of it. Was valued at rupees 36 crores. The paragraph, the documents in connection with the title of the plaintiffs has been detailed in paragraph 2 of the plaint, which being not in dispute need not be discussed. The property of the plaintiffs, now it has already been recorded that schedule 1 was admittedly the property of the plaintiffs. It was the case of the plaintiff that the schedule 1 property was recorded in last survey settlement in record of rights by new khata number 158, bearing new plot number 27 and 27/1718 in the name of state of Bihar, and was in possession of their father. Consequently, a title suit number 18 of 2003 of 1973 was filed by the father of the plaintiffs against the state of Bihar, which was decreed in their favor in the year 1976. And subsequently, the appellate decree was also passed in favor of the plaintiffs, and ultimately having won, they applied for fixation of rent, which was duly fixed in rent fixation case number 15 with the bracket KA bracket close slash 1991 and 1992. The plaintiffs were 4 brothers and they all came in possession of the property. बाकी दोनों का क्या?
उसका कहीं पर आया कि वो लोग एक जन मिसिंग है और फोर्थ का आया नहीं. So out of them 2 executed, this is not in dispute.
Ultimately, the plaintiffs transferred Schedule 2 and Schedule 3 land in favor of the defendant by executing the 2 registered sale deeds dated 7/2/14 and 17/5/2014, which are the subject matter of the present suit. The specific case of the plaintiff was that at the time of execution of registered sale deed dated 7/2/2014, total consideration amount of ₹62 lakhs was paid through 4 checks.
62 lakh 70,000.
62 lakh 70,000 was paid through 4 checks. The details of which have been mentioned in paragraph 8 of the plaint and also in the registered sale deed. This aspect of the matter is also not in dispute. Correct?
Yes.
मैं उनसे पूछना जरूरी है ना, कोई dispute है तो बोलेगा. Their further case was that the checks which have been mentioned in sale deed dated 7/2/2014 was never encashed by the plaintiffs and it remained in their custody. It was further case that on 22/2/2014, the defendant gave a letter to the plaintiff stating that the property registered in their favor shall only be stating that the property was registered in favor of the defendant for a total consideration amount as mentioned above, and the same shall only be paid to the plaintiff by defendant after mutation is done in his favor. The defendant also mentioned that he was informed that the mutation of the land cannot be done as the land is recorded in the name of state of Jharkhand. It was stated that although the land were subject matter of degree in title suit filed by the plaintiff against the state of Bihar, Jharkhand. Thereafter, the defendant directed the plaintiff to return all the checks mentioned in the sale deed dated 7/2/2014 and also asked the plaintiff to take steps for cancellation of the sale deed. ये अभी तक एक ही सेल डीड का बात चल रहा है ना?
नहीं, ये फर्स्ट सेल डीड का अभी तक बात चल रहा है, पैरा 12 का.
पैरा 12, ठीक.
लेकिन सेम स्टोरी है पैरा 13 से सेकंड सेल.
Yes. It was also stated that mutation was not the precondition for execution of registration and payment of sale consideration by the defendant. However, the defendant again issued a letter dated 28/3/2014 by referring to his earlier letter dated 22/2/2014 asking the plaintiff to arrange return of all the checks issued in favor of the plaintiff immediately, otherwise the defendant shall take necessary legal action against the plaintiff, which was followed by Consequently, the plaintiff returned all the checks to the defendant by letter dated 8/4/2014, on which the defendant had put his signature in token of proof of the receipt of all the 4 checks. The 2 sale deeds dated 7/2/14 and 17/5/14 were annexed as annexure 2A and 2B, and the aforesaid letters dated 22/2/2014, 28/3/2014 and 8/4/2014 were annexed as annexure 3 to the plate. It is further case of the plaintiff that, so far as the other sale deed is concerned, which is the total consideration amount of rupees 39,60,000, which was also paid through check as mentioned in the sale deed itself, were also returned on 1/7/2014, and the defendant had put his signature in token of proof of the receipt of the 4 checks. The 3 letters in connection with the second sale deed, that is sale deed dated 17/5/2014, were letter dated 1/6/2014, 15/6/2014, 1/7/2014, which were marked as annexure 4, which were annexed as annexure 4 to the plate. Further case of the plaintiff was that the defendant, after receipt of his checks from the plaintiff, which were not encashed, managed to obtain the sale deeds from the office of the registrar at Jamshedpur in a clandestine manner without giving information to the plaintiff on the basis of registration slip, which was handed over to the defendant in good faith by the plaintiffs. It was also stated that the possession of the property in Schedule 2 and 3 was not delivered to the defendant by the plaintiff, although the registration slip was handed over on the basis of earlier checks received by the plaintiff. The case of the plaintiff is that the 2 registered sale deed numbers 7/2/2014 and 17/5/2014 executed by the defendant had no legal value in the eyes of law, because the sale consideration was not paid to the plaintiff and the delivery of possession was also not given to the defendant even after registration and execution of the sale of the registered sale deeds. And consequently, the case of the plaintiffs was that the 2 registered sale deeds have no value in the eyes of law, being without consideration, and both the sale deeds were required to be declared null and void on this count. The plaintiffs, however, issued legal notice dated 23/8/2016 asking the defendant to return both the registered sale deed. The defendants responded to the legal notice by reply dated 9/9/2016, whereby the defendant claimed to be the owner of the 2 registered sale deed. It was a case of the plaintiff that the defendant had intentionally and deliberately cheated the plaintiff by taking back all his 8 checks and after getting the sale deed registered in his favor. the case of the plaintiff was that the two registered sale deeds did not convey any title to the plaintiff, and it was repudiated by the plaintiff by notice dated 23/8/2016. And therefore the plaintiff defendant was not entitled to claim any right, title, interest or possession with respect to Schedule 2 and Schedule 3 land. It was further case of the plaintiff that they have executed another agreement in favor of another person for transfer of land mentioned in Schedule 4, and the possession of the same was also delivered to said person for construction of building. It was asserted that only fixed court fees of rupees 250 was payable, as the suit was of declaratory nature. The sole defendant contested the suit by filing a written statement. Non-joiner वगैरह भी है क्या आपका plea? नहीं है ना? Material plea है?
में लिया हुआ है।
Formal कुछ है उसमें कि उसको लिखना है कि नहीं लिखना है? सिर्फ
एक
तो अगर नहीं है कंटेस्ट उस पे तो क्या लिखना है?
चलिए ना बहस करेंगे उसको देखेंगे।
The suit was, it was asserted that the suit was not maintainable in the present form, there was no valid cause of action, suit was barred by the provisions of Transfer Property Act, suit was barred by the principles of estoppel, waiver and acquiescence, the suit was barred for misjoinder and non-joinder of missing parties, and causes of action for the suit, and the suit was barred, the suit was barred under the provisions of Specific Relief Act, and the suit was grossly undervalued. It was asserted that the plaintiffs had paid for return of two savings whose value was rupees 62.70 lakhs and 39.60 lakhs respectively, total be rupees 1.1, 02, 30, 000. But the suit was valued at rupees 36 lakhs. It was also asserted that the plaintiffs assumed that the sale deeds were null and void and avoided to make a prayer for cancellation of sale deed. And this was done evidently to evade payment of full ad valorem fees. Another objection was taken by stating that the plaintiffs had filed one title suit number 74 of 2015 against the defendant seeking cancellation of their constituent savings by paying ad valorem court fees of rupees 50,000. Later on, plaintiffs withdrew the sale title suit unconditionally, but this vital fact was suppressed by the plaintiff before the court. It was asserted that the plaintiffs are stopped from assuming and alleging that the two sale deeds were null and void and the same were not acted upon. The fact regarding ownership of the property with the plaintiffs. The fact that the plaintiffs were the owner of the property and the agreements were, and the sale deeds were executed and the checks were issued were not in dispute in the written statement. However, it was stated that although it was agreed between the parties that the checks issued by the defendant and mentioned in the sale deeds dated 7/2014 and 17/2014 will be encashed by the plaintiff only after mutation in respect of the lands mentioned in the two sale deeds. And in pursuance thereof, the plaintiffs retain those checks with them. Still, the defendant, however, it was also mentioned that still the defendant paid the entire consideration amount of ₹1,02,30,000, $0,000 to the plaintiffs and stroke or their relatives as per their requirement and direction, partly by cash and partly by bank transaction, on receipt of the aforesaid checks mentioned in the two sale deeds. And therefore, it was asserted by the defendant that the entire consideration amount with respect to the two sale deeds was duly paid, even though the checks were not encashed. It was also asserted that the plaintiffs neither filed money suit claiming the consideration amount. It was also asserted that in the aforesaid circumstances, the plaintiff neither filed money suit claiming consideration amount mentioned in the sale deed, nor proceeded with earlier title suit number 74 of 2015, which was filed seeking cancellation of the two registered sale deeds. It was further case of the defendant that the plaintiff voluntarily gave the registration slips in respect of the two sale deeds and also delivered physical possession of the land mentioned in the schedules, within bracket schedule 2 and 3, bracket close. The defendant admitted to have collected the original sale deeds from the registration office on completion of registration of the same, and they then applied for mutation of the land. It was asserted that having received the full consideration amount with respect to the two sale deeds, the plaintiffs were stopped from challenging the validity of the same. The defendant denied the plea of repudiation of any agreement for sale by the defendant. And that the plaintiffs have not disclosed the particulars of any such agreement for sale. ये कौन सा agreement for sale? इसका क्या relevance? There is no repudiation of any agreement of sale. Para number 12.
कुछ तो वो हम भी नहीं समझे।
हाँ बताइए आपका written statement है, which is what is it?
Legal notice में था।
Repudiation of agreement का तो कोई कहानी इसमें तो नहीं है, plaint में भी नहीं,
इनके notice में है, which they rely upon in the plaint।
Plaint में नहीं है।
Plaint।
You are referring to paragraph 18 and 19 of the plaint. 18 and 19 is not referring to any repudiation of any agreement of sale.
18 and 19 refer to their notices,
That's
which
right.
in turn refers to this repudiation.
Repudiation of,
You will have to see those notices.
and also due to repudiation of both the agreements.
Paragraph 19.
Okay.
Plaint.
See,
Has leadership seen?
is absolutely. And that the plaintiffs never disclosed any particulars of agreement of sale. It was their case that having received the full consideration money according to their own requirement and direction, in lieu of encashment of checks mentioned in the sale deeds, the plaintiffs were stopped from challenging the validity of the two sale deeds, and therefore there was no question of any return of the two sale deeds to the plaintiffs. And the reply to the legal notice was given in those lines. The allegation of cheating was also denied. it was asserted that after taking possession of the lands purchased by the defendant through the two salients, the defendant commenced construction of several residential premises thereon after levelling the same by expending huge amount of money. Out of greed to grab those premises or alternatively to extract money illegally, the suit was filed by the plaintiffs at the instigation of some mischief mongers. The defendant asserted that the title to the land passes with the execution and registration of the sale deed, and therefore the transferor cannot retain any right over the land which has already been transferred by way of registered sale deed. It was also asserted that the sale of immovable property is complete even on promise to pay the price of the land. The defendant had already paid the full sale price of the land purchased by him, and therefore the notice issued by the plaintiff dated 23/8/2016 was absolutely absurd and illegal. It was reiterated that the plaintiffs are not entitled to original sale deed and the same were not obtained by the defendant in a clandestine manner. Rather, the plaintiffs themselves had handed over the registration receipt in respect of the sale deeds in question and made necessary endorsement in the registration receipt, on the basis of which the defendant had collected the original sale deeds after completion of registration. It was asserted that once having received the full consideration money as mentioned in the sale deeds and having endorsed the registration receipts in favor of the defendants, the plaintiffs acquired no right to receive the original sale deed either from the defendant or from the registration office itself. It was asserted that out of their own wishes, the plaintiff did not produce the checks mentioned in the two sale deeds to the bank for realization of payment of the amount mentioned thereon. Anyhow, as a good gesture and being a bona fide purchaser, the defendant paid the entire value of the land mentioned in the two registered sale deeds as per the request and requirement of the plaintiff in cash and bank transactions. Upon receiving back the checks in question. With respect to the transaction with another person, it was asserted that upon careful perusal of Schedule 1 to 4 of the claim, it would be evident that the land mentioned in Schedule 4 was never in possession of the plaintiffs. The major portion of Schedule 4 is in possession of the defendant since the date of execution and registration of the two sale deeds in question, and that the defendant was raising construction of building in Schedule 2 and 3 land, which he had purchased by sale deeds. It was also asserted that admittedly Schedule 4 includes major Schedule 2 and Schedule 3 purchased by the defendant, and asserted that except the defendant, no other person was making any construction on any part of Schedule 1 land. It was asserted that the plaintiff had no cause of action and was not entitled to any relief. However, along with the written statement, no document as such was annexed. इसके साथ तो कुछ annexation नहीं. On behalf of the plaintiffs, कितना evidence हुआ है? Yes, यहाँ पर include that नहीं. on behalf of the plaintiffs, include agenda page number 12. Next, the following issues were framed by the learned tribunal, para 4, and on behalf of plaintiffs altogether, three witnesses were examined. Plaintiff number 1 and 2 were examined.
Both plaintiffs.
And including both the plaintiffs. Plaintiff number 1 was examined as PW.
Satyamohan Raju is PW1.
PW1, and plaintiff number 2 was PW3. And Arun Kumar Thakur
Nahi,
was PW2. PW2 is Arun Kumar.
yes, only one plaintiff has been examined. And
PW1 is Satyamohan Raju, PW1.
yes,
PW3 भी कोई राजू है.
वो है Dandu. He is the son of Shivram Mohan Raju, who is the defendant number 2.
अच्छा. PW1, plaintiff number 1 has been examined as PW1. PW3 is son of plaintiff number 2 and claims to be aware of all the transactions. PW2 is Arun Kumar Thakur, who is said to be the power of attorney, general power of attorney holder,
with whom the plaintiffs had entered into an agreement with regard to Schedule 4.
with whom the plaintiffs have entered into agreement with respect to Schedule 4 of the The plaintiffs exhibited the following documents. ये है page number 12 में. Okay. The defendant number 1, the defendant was examined as DW1, and DW2 is the son of the defendant number 1. The following documents were exhibited on behalf of the defendant, page number 16 में. The issue number 1 was taken up by the learned tribunal. इसका खाली डिसीजन बताइएगा. Against the defendant.
It starts from page.
It was held. Sorry. क्या finding है?
It starts from page. It ends in page 24.
हाँ, क्या finding किया?
Hence, in the light of our aforesaid discussion, it cannot be held that the plaintiffs were entitled to lawful possession of the said deed, since the plaintiffs have not been able to establish the same has been wrongfully transferred from them.
So basically, it was held to be maintainable, but on merits, the plaintiff did not have this.
No, the court says that the maintainability also, it says that
the issue number 1 was decided by observing as follows. इतना ही खाली लिख देते हैं.
because
Quote करना. Hence, in the light of the aforesaid discussion, it cannot be held that the plaintiffs were entitled to the lawful possession of the same deeds, since the plaintiffs have been able to establish the same have not been able to establish the same had been wrongfully transferred from them to the defendant, and hence no relief of return of sale deeds can be granted to the plaintiffs. Thus, the suit was held to be not maintainable in the present. यही impact.
हाँ impact हुई है.
Inverted comma close करके. Thus, it appears that the learned trial court was of the view that the suit was not maintainable in the present form. With respect to issue number 2,
The plaintiff has not been able to show as to why return of document which they themselves have pleaded have no value, because it was whether valid.
present issue is decided against the defendant. Yes. ये जो लास्ट टाइम लिखे हैं ना, यहाँ पे लिखे हैं कि बस इतना ही खाली कोट करते हैं. Hence no relief of return of sale deed can be granted to the plaintiffs. उसके बाद अपना एक भी observation है. By deciding issue number 2, the learned court ultimately held the court held that the plaintiff had no cause of action. पूरा reading से तो वही. Thereafter, the learned trial court took issue number 3, 4, and Roman 9.
Finding is at page 28.
And
Last.
the finding has been recorded in page number 28.
Hence, in the absence of
and all these issues were decided against the plaintiff. ठीक है? By deciding issue number 6, the court held that in the light of the fact that the suit was withdrawn with the permission to file fresh suit, the filing of earlier suit and its subsequent withdrawal cannot be held to be a bar for the present suit. But however held that other issues having been decided against the plaintiff, but however observed that the other issues were already decided against the plaintiff. यही है?
हाँ.
While deciding issue number 7, इसमें तो कोई point ही नहीं है. इसमें तो decide
पता नहीं है क्यों, लेकिन ठीक है, because the court has, the lordship is
the
recording
court
the
held that the defendant had not denied the capacity of the plaintiff to make a valid transfer of land described in the duty of the plaintiff. Just last time. Last sentence is just before. The defendant has not denied the capacity of the plaintiffs to make a valid transfer of the land described in the schedule of the plaintiff. However, since the suit was held to be not maintainable, the issue of whether the plaintiff had entitlement to sell the property was decided accordingly.
Everything now is being referred to maintainability.
ध्यान से पढ़िए ना तो
Mr.
आपका ये सब जजमेंट देख के
Mr.
दिमाग
Neeraj, he would support this judgment.
that is not his judgment.
Yeah, he'll justify as to how.
But this is his judgment that I would support.
By deciding issue number 7. इससे कुछ आपको कोट ही करना पड़ेगा क्योंकि इतना कॉम्प्रिहेंसिबल ही नहीं है क्या लिखे कौन है ये राइटर है जल्दी एक सेंटेंस का दूसरे से कोई लिंक ही नहीं It has been held that it is settled principle of law that the registered instrument of transfer providing for sale of immovable property shall be held to be valid transfer on sale and consideration amount may be part paid or completely paid or may even be promised to be paid. The court also held that there will be corrections in this. The court also held that the defendant has admitted the payment of consideration was made by other mode than specified in the sale deed marked Exhibit 1 and 1/1. In connection with which detailed discussion was made by deciding issue number 1, the court held that the sale deed cannot be held to be void on the ground that no sale consideration had passed the plaintiff. By deciding issue number 5, the court was of the view that since only return of the series was sought and no recovery of possession was sought, a total of rupees 250 as fees has been paid. And the court held that the suit does not appear to be undervalued. The issue number 10 was decided by holding that the plaintiff is not entitled to any relief and ultimately the suit was dismissed. हाँ, बताइए आपको क्या बोलना? एक सेकंड, 3 जाते हैं ना? हाँ. एक लिस्ट में क्या दे दिया? The legal counsel for the applicant has relied upon the following documents. Yes, please.
Yes. The sale deed being null and void is different from sale being null and void. In a given case, sale can be null and void. Assuming this plea could be allowed to be raised by them. Nevertheless, the registered sale deed itself.
No, I would like to bifurcate your argument into parts. One is what is your specific case, and then assuming it to be so, then also you have this.
No, I was starting with the legal proposition. They have tried to set up a case that the sale deed was wrong, based on the premise that consideration had not passed on. Question is whether the court should go into that issue or not. That's the first threshold which has to be passed. I am on section 34. The sale deed, regardless of consideration passing or not passing, is a valid document otherwise. Your ladyship knows that whenever a document is required to be registered, and it has not been registered, nevertheless, the effects of non-registration is not that the document is a waste paper. It can be a valid piece of evidence of incidental transactions. For example, possession. For example, passing of consideration. This sale deed is a valid document so as to prove that the possession has come to me. If they were to succeed on the point that the title did not pass on because ultimately the consideration did not pass on. Question is, what about possession? If the possession is with me and they have not prayed for delivery of possession, which is essentially consequential relief to be sought for by a person who is seeking declaration of title in his favor, then bar under the proviso of section 34 would operate. To say that deed should be returned to me because it is null and void amounts to seeking a declaration. That's the highest argument that they can make, in support of which they have given some judgments also. Let me concede it for a moment. That yes, mere assertion in the plaint that the document is null and void, and the fact that it has been controverted in the defendant's assertion, constitutes an issue, framed or not framed, invites adjudication, and the court adjudicates upon it. That's a declaration. If the court says, incidentally also, while dealing with the issue of return of an immovable property, that the property is not falling within the title of the gentleman, then it's akin to giving a declaration. Now let's assume that there is a declaration of title sought for. Question is, what is the law of the land with regard to a declaratory relief being sought? And that is where section 34 comes in. Leonard Freda cited judgments which say that if you have sought for consequential reliefs, the fact that you have specifically sought for declaratory relief will not make any difference, because your consequential relief is based on the premise that there are pleadings that you have got the title. But that the vice versa is not true. If they are seeking for declaration directly or indirectly, specifically or not so specifically, they have to seek the essential relief of possession, which they have not sought for.
If a person claims to be in possession, then also he has to seek a relief for.
It is his risk, because what we do normally is
risk. That's fair enough.
Yes, in this case, that risk has been proved to be fatal.
He has taken that risk.
He has taken that risk.
But he claims that he is in possession of the property. If a person is already in possession of the property, he need not seek.
But he has to prove that he is in possession, which he has failed. In this case, yes.
When did the possession pass, according to you?
As per the deed, at the time of registration of the deed.
No.
Yes,
Possession does not pass by registration of the deed.
No. It's stated in that deed.
And what is your written statement?
My written statement is that I am in possession.
No, that is you are in possession. When did the possession pass? As per your written statement. Just a moment. So, they gave you the registration slip, that is post-registration, and also delivered you the possession. So, it is not your case that.
No, it's not stated that the possession has been granted along with the registration slip.
It is mentioned, yes, the plaintiff voluntarily gave the registration slip in respect of the two sale deeds and also delivered the possession of the land.
It's not that both happened simultaneously.
You have not given any date.
No, I haven't.
You were in possession.
I haven't. Therefore, we have to see the deed.
Well, therefore, you see, the deed does not say that you are already in possession.
And assuming that yes, it was, my case is that it was delivered along with the receipt, the registration slip, that's an admitted fact that the registration slip was given to me.
Yes, registration slip, there are two different incidents.
Therefore, possession was given along with it or before that, hardly matters.
It matters. It does matter. Right? Your case is that registration slip was given to you. Voluntarily given.
And possession.
And possession. Handing over of registration slip is not in dispute. They say that it was fraudulently done. That is a separate, right? But handing over of registration slip and the fact that you have taken the deed from the registry office is not in dispute.
Possession is in this.
Possession is in dispute as to when did you take the possession. So when you refer to the deed to say that the possession was handed over to you even at the time of execution of the deed is not reflecting from your written statement. So therefore, statement in the once the transactions are in dispute, it has to be proved, right? Merely it only has a presumption, nothing more. When the transactions are in dispute, then it has to be proved. So your case that the deed itself would suggest that you were in possession is slightly on a slippery limit.
Therefore, one would fail if no evidence is given from either side. Would fail.
No, once they say, that's it. We have to examine that. We need to examine that. What is the consequence? But this is where
Therefore,
your
they were in a position. They were in a position to invoke the provisions of CPC to get the issue of possession settled with the help of local investigation, inspection,
That's right.
whatever.
They claim that they are in possession. They did not. Therefore, the suit by itself is not barred by section. If a person is in possession,
No, suit by
you see, when you say that the suit was barred by section 34,
that will trigger, that argument will trigger only if my case is that possession is not with him.
that's right. That's your back.
Therefore, the moment I say possession is not with him but with me,
This is subject matter of
Of trial.
adjudication. Right?
leadership
But
maintainability.
on the face of section 34, if a person claims to be in possession, he did not ask for recovery of possession. Therefore, the suit by itself is not to be
I'm getting
made by
let
section
me answer it in one sentence. 34 is never to be examined at the threshold. And therefore, on the ground of 34, order 7, rule 7 is not attracted. The law is that if factum of possession is denied by the other side, then it is their duty to amend their claim and seek an appropriate relief of alternative prayer of recovery of possession in the event the plaintiff is found to be not in possession.
Not this.
That we will see.
Not this.
That we will see. That's my case. If yes, that's specifically my case. It was their duty faced with the denial.
The learned counsel for the respondent has commenced the argument. He has submitted that the case of the plaintiff is that sale deed was void based on a plea that consideration had not passed. He submits that the sale deed is valid regardless of passing of the consideration amount. And the sale deed itself shows passing of possession. Therefore, the suit was barred by section 24 of the specific
Leadership, that first we have yet to argue. Leadership, that it is regardless of passing of the
You have submitted that record.
I said assuming they could argue, they could be allowed to argue this. So far I have only pleaded that with regard to possession part. That second aspect can be deleted for the moment. Tomorrow I will argue whether I don't admit that sale deed has consideration is not passed. I don't say that consideration is not passed.
Without admission, without admission that the consideration has not passed,
Great.
it has been argued. Uske baad.
Great.
Further tomorrow.
Can I reply on Monday? He'll take time. इनका 2 घंटा पहले नहीं होगा.
इनका जजमेंट इतना है ना, so prejudiced towards me. मेरा नाम राजू.
कल तैयारी करनी है. जरूरत होगा तो हम आपको देंगे.
मतलब
अच्छा ठीक.
मंडे को
आप एज्यूम क्यों कर रहे हैं?
नहीं ये नहीं.
अगर मंडे को इनको कोई डिफिकल्टी है तो मंडे को ही रख लिया जाए.
नहीं मंडे को नहीं रखेंगे.
जी.
आपको अगर जरूरत पड़ेगी तो हम टाइम जरूर से देंगे.
ठीक है. So he'll be there therefore.
नहीं आप इससे मत करिए. You see, you have to respond to the arguments. आपको कहीं और जाना है?
कल हम पर्सनल काम था इसी के लिए.
कल का डे इनका मन में नहीं आता इसलिए.
नहीं ठीक
Monday
है.
नहीं.
ठीक है.
at your risk. Because there may be many questions which I may be asking which he will not be able to respond at all. These are absolutely pure legal issues. अब पोजीशन की बात है, आप सुन रहे हैं, आपको लगता है कि आप आपके एब्सेंस में ये सारी चीजों को हम क्लैरिफाई कर पाएंगे?
नहीं, हम तो बोले शुरू में ही, हम बोले कि आई मल्टीपल डिफिकल्टीज
बहुत इंट्रिकेट क्वेश्चन है. We have to decide in a case where checks are issued and shown as consideration amount in the same. What is the consequence if the check is ultimately not for whatsoever reason? Right? Whether it requires a decree for cancellation of sale deed or the sale deed itself would be done. यही है ना? इसके बिना तो कुछ नहीं होगा. तो ये तो समझना होगा ना. तो आप इतना
ठीक है, कल